I'm going to today talk about and lead this off and talk about just some of the legal underpinnings and some of the issues relating especially to labor contracts, okay, and a variety of things. I'll be touching on some areas that some later presenters are going to be speaking more in depth to, and I'll indicate that when I get there. First of all, I just wanted to review briefly in just a list format here, and most of you are familiar with these sources. Chapter 110.227, which is one of the sort of the major statutory provision we use in dealing with career service people and discipline. The portion of the Department of Management Services rules, Chapter 60L 36. Each collective bargaining agreement, those of you who have spent time with the collective bargaining agreements will realize that each of them has a discipline article in it, at least those of the career service contracts do, and agency policies and procedures. So this is where, you know, if you're getting involved in disciplining employees, this is sort of the starting point in being sure that you're familiar with these various provisions. Put together here a checklist, and I'm sorry this is up at the top of the screen here. You can see that I've got some things to learn about putting PowerPoints together. This is titled Checklist Before Taking Disciplinary Action. As I just mentioned, you just saw the list of statutes, rules, agency standards. Even though in many instances our employees aren't aware of the fact that they're covered by a collective bargaining agreement, because of most of our employees are not members of the unions that represent them. Nonetheless, you're also aware that those collective bargaining agreements govern their employment. So the point is, if you're getting involved in discipline with an individual who's a member of a bargaining unit, you need to be sure to review the provisions of that collective bargaining agreement that apply to that employee. Because if you don't, down the road, it may prove a really significant procedural hurdle for you. There is in the statutes a Law Enforcement and Firefighters Bill of Rights, which set out some extensive procedures around disciplining, interrogating employees in those groups. Of course, you're going to be looking at the employee's record, their personnel file, the evidence that's present, past practice, which can be very significant with respect to collective bargaining matters, because you can, in some cases, create a right in an individual as a result of the practices that your agency is engaging in around a particular type of event, and mitigating circumstances. And I don't mean to minimize this last one. We'll be talking in much more depth. I know Ms. Renovich will, the labor arbitrator, will be talking about that, as will Mr. Morton from PERC. I wanted to just spend a minute on an area that is a kind of a specialized area, but it's something significant, again, with respect to dealing with employees who are members of a bargaining unit. As indicated here, back in 1975, the U.S. Supreme Court set out the rights that a unionized employee has when they are to be interviewed in an investigatory type interview where you're seeking to gather information from them. And you'll see here what the court, first of all, identified as an investigatory interview. First of all, this is an interview where you're seeking information from an employee. This is not an interview where you're taking something and handing it to them and saying, we're giving you a oral reprimand or a written reprimand. This is where you're seeking to get information from them that may be used in a disciplinary matter. The second part of this test is the employee has a reasonable belief that the employee may be disciplined or suffer other adverse consequences as a result of what they're being asked. So if in the mind of a reasonable person, and I know everybody in this room can easily identify a reasonable person because that would be you, in the mind of a reasonable person, if you're being asked questions that you believe would possibly reasonably result in some kind of adverse action against you, then you have the right to request a union representative at that interview. The best way to proceed to cut off last-minute issues around this would be to give the employee up front an opportunity to have the union or other rep present. You're not required to do that. But what that prevents is you're getting into an interview, then an employee asks for a union representative or some other representative, and you're in a position where you've either got to halt the interview, in most cases because there's not going to be a union rep present immediately, and you're going to have to, just from a logistics scheduling standpoint, you've got the potential of having issues. But you're not required to do that. You can wait and see if the employee requests representation. And this, what we're talking about, would apply equally to a predetermination conference. The next bullet there, you see the employee can ask for this before or at any time during the interview. So an employee could get into an interview and say, you know, at this point, I would like to have union representation. That doesn't mean what they've shared up until then is off limits, but it certainly would, at that point, cut off the remainder of the interview. Those of you who spend your time watching crime shows on TV are aware of this process in terms of people who are being accused asking for representation. One of the issues that arises here is what's reasonable in terms of delaying an interview in order for the employee to identify a union rep. Ms. Hunter reminded me of that yesterday because she's had that experience, and some of you have as well. There's no bright line standard here in terms of how long is reasonable to wait. We've had situations where we've had moratoriums for grievances. We've had union reps that have been ill and weren't available for a week. One of the problems we have is a number of our unions don't have a ready supply of representatives. So that's just an immediate issue that's an issue for them. If there's something urgent, then what I would suggest you do is either make direct contact to the union leadership or call our office and let us see if we can attempt to negotiate that with the union to find somebody who can be available, because you're going to want to proceed with that possible disciplinary matter. You can see here, and I think this is probably apparent if you think through this, there are basically three outcomes where an employee asks for representation. You can say, all right, assuming there's a representative who can come to the interview on short notice. You can deny the request and end the interview and reschedule it when the rep's available, or you can just say to the employee, would you like to go ahead? Are you willing to go ahead? Or you can end it. So you give the employee a choice. If the employer, and I get this really follows, if you deny the request for union representation, the employee can refuse to answer questions. So that's Weingarten in 5 minutes.
Jim, just had a quick question. Does the employer have to advise
No.
the employee of their Weingarten?
No, that's not part of the Weingarten. But what I would suggest you do in each instance is you consult the collective bargaining agreement, because there's language in each agreement that's worded a little differently, okay? So be sure when you get involved in this type of an interview, disciplinary interview with an employee who's represented by a union, who's covered by a collective bargaining agreement, be sure that you reference that collective bargaining agreement before you get involved in this, just so you're absolutely sure what the provisions are in that agreement that addresses this. And there may not, in a couple of the contracts, I don't think there are any, or it's very generally worded, and other is more specific. Again, just last, Weingarten rights do not apply. I indicated earlier where you're actually delivering discipline, you're not interviewing somebody to gather information. If you're interviewing fact witnesses, not the individual who's potentially going to be disciplined, this doesn't apply. And also, if you're talking to employees about assignments, schedules, performance issues, Now, in some cases, if you're dealing with a performance matter that could result in suspensions or dismissals, you may implicate Weingarten rights. And the last point here is just the role of the union rep. The union rep's not to come in and speak for the employee. They're to be there to assist. They may ask a question or so, but they're not to run the interview. They're not to be there in place of the employee. This type, well, you can see it here, effective criminal proceedings. Again, most of you have had experience with this, where you have an employee who's charged with a crime and you want to take action. The first bullet here, make a good faith investigation, don't rely solely on criminal charges. I'm aware of cases where agencies have gone in and they have a charging document that they're using as evidence. If you go before an arbitrator, go before PERC, that in most cases is going to be insufficient. You're going to have independent evidence. You're going to have to put on witnesses with respect to what happened, whether you can get law enforcement. This is a challenge, I know, but it's not enough that clearly that the person has been charged with a crime. You're going to have to produce evidence that they have violated whatever rules or policies that you have in place, and you're going to have to do that independently. You can't rely on just the documents that are out there with respect to the criminal charges. And you can see some of the other considerations here. Agency has a legitimate concern for the safety, obviously. If you have a situation where the person can't render services, disqualifies from that. You have some other alternatives there. Of course, you can put the person on leave. You can suspend them and so on. So there's some options you have. But I just wanted to put this slide in here to remind us all that there are circumstances where you can move forward without waiting for a final determination in the courts. This says what can happen even if you do everything right. You're all aware of that. What can happen is a variety of things, and I'm going to touch on all of these. Career service grievance under the statutes, appeal to PERC, grievance arbitration under the collective bargaining contract, unfair labor practice charge with PERC, or you could get a complaint through the Florida Commission on Human Relations, and there are going to be speakers here today who will be speaking to all of these except the unfair labor practice area, and I'm going to touch on that in a minute. Wanted to talk for a minute about due process, because that actually is where almost all of what we're talking about starts. The provision of the U.S. and Florida Constitution that provides for due process before a person can be, as is indicated there, deprived of life, liberty, and property. Fortunately, we're not talking about life today, so we'll narrow it down to liberty and property. A liberty interest is something that we very rarely talk about, but has been recognized by the Supreme Court and other courts. And it's an interest, it's a property right that's implicated when there is some significant impingement on an individual's ability to secure future employment. So if you have an individual, and this includes SES employees, this is not limited to career service employees, SES, SMS, any employee. If the reason for the employee's termination involves moral turpitude, something that could jeopardize their ability to secure future employment, then you have potentially a liberty interest. I'm not going to go into that in depth. If any of you are interested in that, I've got about a 3-page outline on my computer. I can send you about this. We haven't given this a lot of visibility, but it's out there. So those of you, especially the council who are here, it's good to know that it's there. Again, what we ordinarily focus on is property rights, which is, as the Supreme Court has determined, is an interest which we create, the legislature creates, agencies can create by, as you can see there, by contract, by law, by rule. An example would be permanent status. That's something that the state has created with respect to career service employees in a particular position. So that's a property right. Due process, as you know, is a sliding type of procedure, i.e., the more significant the property right you're being deprived of, the more significant the procedures that are going to be necessary before you take that away from the person. The one end of the spectrum, of course, is life. So when we sentence somebody to death, we oftentimes take 8 to 10 years to get there, working through various considerations with respect to due process. And the other end of the spectrum is probably somebody who has some, perhaps is suspended for a few days with respect to their pay. Property rights and employment, I just indicated. You can see all the ways that we create property rights. And I want to make a comment here. Sometimes, with respect to property rights, we create our own problems. By that I mean, when you, with the best of intentions, decide in your agency that you're going to put in place policies, procedures, performance improvement plans, all of the things that we put out there in writing, that we commit ourselves to. When we do that, what we're doing is creating potentially property rights for the employee. So the more you put in writing, the more you say that you're going to do, if you don't follow your own procedures, if you don't make good on what you've committed to do in your rules, in your policies, procedures, documents, you can be held accountable for that, whether it's by an arbitrator or by someone else, and say, well, you committed to do X, Y, and Z, and you didn't do these things. You didn't meet with the employee every 2 weeks. You met with them every 2 months. You didn't provide them with a written statement every month as to how they were failing in their performance, and so on. So be careful what you create with respect to this, because it can come back to be something that an employee can assert as being, you've dealt with them with this issue insufficiently, and you haven't made good on what you've committed to. This is what is cause to discipline, cause in quotes. Again, I imagine almost everybody in the room is aware that in Section 110.227.1 of the statutes, it provides a definition of cause for dismissal or suspension of a career service employee. And you can read it. I'm not going to read this to you. You can see the grounds there for cause under state statutes. Notice the first one is poor performance. So what we have done in the state is we treat performance as a grounds, and we have to demonstrate cause the same way we would if somebody's involved in insubordination in what we would ordinarily call misconduct. So we've included performance in that. So as you're going to hear from, I think, from PERC and from the arbitrator, regardless of the reason, if it requires cause, you're going to have to demonstrate the same kind of a showing. You're going to have the same legal standard to satisfy your burden of proof with respect to that. Just cause, which is what this is, this slide, is included in almost all the contracts. Some of them just say cause, some of them say just cause. This is really significant with respect to labor arbitrations. Those of you who have had the experience of being involved in labor arbitrations know, and Ms. Renovich this afternoon is going to talk in depth about this, how arbitrators over the years have defined just cause and the standards they apply. These standards are not identical to what the PERC hearing officers apply. They're not necessarily identical to what a court would apply. And they're not, arbitrators in applying just cause are not bound by very narrowly what's in your rule. They're going to apply a just cause standard again, unless the collective bargaining agreement that they're interpreting or applying provides for something else. But ordinarily in a discipline matter that comes before an arbitrator, they're going to apply just cause. Essentially what just cause is, it's a body of arbitral precedent over the years that is their version of due process. I mean, if you want to think about it that way. It's what the way arbitrators define due process in disciplinary matters. Talk for a minute about predetermination conferences, which is the way that we satisfy due process when we're taking property rights away, termination, suspension, demotion, anything that involves money, that involves a person's employment. There's a lead case, the Loudermill case, came down in 1985, which set out the standards, the due process standards. This was a case where, as is the case with predetermination, a case where there had not been a final disciplinary decision made. There was a post-termination hearing available, such as we have in the case of labor contracts. It's arbitration. The case of PERC, it's going and having a hearing. So those are the facts that were present in the Loudermill case. You can see here the standards that the Supreme Court set out, and these are the standards that are integrated into our predetermination process in Florida. Most of the states, governments, put these in place after the Loudermill decision came down. The first one there, charges sufficient detail to enable the employee to respond to them. I had occasion recently of looking at a document that laid out what were purporting to be charges, but were essentially just very general statements about what an individual had done over a period of like 3 or 4 months. You haven't satisfied your performance standards over 4 months. That kind of a statement and a charge is insufficient with respect to an employee. If you put yourself in that situation, if somebody came to you at the end of 4 or 5 months and say, hey, there's 5 occasions when you haven't met your performance standards and we're going to discipline them for them, the first thing you would ask is what? You would say, okay, what are we talking about here? Which standards, what were the facts around each of these instances, and so on. So, you know, you really can't paint with a broad brush. You've got to get down to the details of what occurred, what the facts were surrounding those particular incidents. Explain what you have. You're supposed to be providing the employee with documents, documentary evidence when you go out with an intent to dismiss or an intent to suspend. The employee, of course, is going to have a predetermination right to a conference to tell their side of the story. They can bring a representative to that conference. We talked about that as with respect to union representative. They can bring anybody they want. Actually, they can bring their uncle or aunt. It doesn't make any difference. And it's not an evidentiary hearing, so they don't have any right to confront witnesses. It's an opportunity essentially for the employee to provide information. But again, the employee is unable to do that effectively if you don't give them enough information up front to know what they're being charged with. Who can file a career service grievance? Now we've moved on to career service grievances. Any employee who has attained permanent status in their current position. You'll notice that the definition of a career service grievance, which ends with the agency head, is extremely broad. I mean, it's basically if you wake up in the morning and you're having a bad morning, I'm joking, of course, but you could have a career service grievance, you know. The condition affecting the employee is unjust, inequitable, or a hindrance to effective operations. That covers a pretty wide swath. So with respect to career service grievances, again, here we don't have predetermination rights on the behalf of the employee. And why is that? Well, if you look at the second part of this slide, the suspensions, reductions in pay, these are the matters that are not covered, as you'll see at the top of the slide. So in other words, what we're doing is we're not infringing in a career servant's grievance on a property right. This isn't a procedure where somebody can go in and contest or deal with these matters where they're being suspended, pays being affected, transfers, demotions, and so on, terminations. So this is a much lesser type of process that's available in these instances, and that's why we don't have all the procedural rights that go into the predetermination process. Collective bargaining agreement grievances. I want to talk for a few minutes about this. Chapter 447 in the labor statute in Florida provides a right to a grievance procedure ending in binding arbitration in each agreement. So this isn't a matter of choice for any employer who is negotiating a labor contract in Florida. One of the starting points is that you have to have a grievance procedure available to interpret, apply the contract that ends in binding arbitration. Now, are there provisions in our labor contracts that are not grievable, in other words, or maybe they're only grievable to a couple steps. Yes, there are, but that's only by virtue of agreement between the parties. Otherwise, everything is grievable to arbitration. First of all, you want to determine, is this person in the bargaining unit? Each contract has in the back of the contract a list of all the classifications. So the first thing you want to check is what the person's job classification is, and check to see if they're in the unit, if they're covered by the agreement. There are in the contracts some limitations and exceptions for probationary employees with respect to some of the rights under the contract. Note, unions can also file grievances on behalf of employees. That's not true ordinarily in a disciplinary matter, but it is in other types of matters. So the unions, in some cases, they're going to be filing class action grievances or grievances representing individuals. Unions have a right to police, if you will, to monitor the labor contract and to insert themselves if they believe it's not being followed. Definition of a grievance under the contract, you can see there a dispute involving interpretation or application of the provisions of the agreement. That is a very important statement because the only matters that are eligible to be grieved and taken to arbitration are those that are set out in the contract. So a union, an employee cannot go over and grab a provision of a rule or a policy or procedure unless it is incorporated by reference into the contract. Otherwise, they're bound to the language of the contract. So that's the first point of reference. In some cases, we have referenced the rules, DMS rules, others, statutes and so on, but we don't do that very often. So usually it's going to be the four corners of the contract are what is going to be subject to grievance and arbitration. Just a list here, the grievance form, this is all set out in the contracts. I just want to remind you what you should be looking for when you get a grievance form in from the unions, and we're doing some work to beef this up in the contract in our negotiations as far as being clearer in terms of what is required each time an individual grieves. But you can see the list there. I don't need to read it to you. Collective bargaining grievances, grievance representation. An interesting provision that, again, we don't talk about much, but it's set out actually in statute, says that the union has a right to attend any meeting called for the resolution of a grievance, even if the union is not representing the employee. So if an employee represents themselves and they want to go forward with a grievance, the state law says that the union has a right to attend a meeting to discuss that grievance. Again, we don't emphasize that much, but I just wanted you to know that is in state law. So if you have that type of a grievance, one thing you might do is give the union a heads up and say, we're having this meeting with Jack, next Wednesday to discuss this grievance. If the employee does elect representation, if you reach agreement with the union, and sometimes this happens, and the employee is not thrilled about the agreement, the grievant is not excited about it or is not really terribly willing, but the union says we're signing off on it, then that becomes binding on the grievance. So they are their agent and representative in that regard. The steps in the grievance process, again, most of you are familiar with these. I just want to point out a couple things. Of course, there are timelines throughout. I'm not going to cover those in terms of how much time is allowed between each step of this process. One of the things we've done within the last couple years is we've removed the Department of Management Services from the review of disciplinary grievances at step 3, which has made a big difference in terms of time it takes to get cases resolved. Because our office was oftentimes taking a month or two to gather all the information from you, review those matters, and then move it, and then put the union in a position of moving it forward. So for grievances that don't involve discipline, our office, DMS, is the third step in the grievance process in reviewing those. And the reason for that is because we negotiate the contract, and we sort of are the keepers of, not the keys, but certainly monitor and have to have oversight in terms of how the contract's being applied and interpreted. But if it's discipline, it would go directly from the agency to arbitration, again, as many of you have had experience with. I'm going to talk about mediation in a minute. And of course, the arbitration is final and binding. That doesn't mean that there's no provision for reviewing arbitration decisions, but those of you who have been involved know under the arbitration code, those provisions are extremely limited. So you can ordinarily expect that an arbitration decision is going to be final and binding. There's very, very limited ability to review that in the courts. Just wanted to lay out here the possibilities of resolving a grievance. Once you have a grievance that's been filed for arbitration, or if it's at step 2 or 3, wherever it is, first of all, you can reach a settlement agreement. Some of you have been pretty effective in this. Sometimes the union just wants the ability to get out of the case, to put it candidly, and they're going to look for some way to sign off if they can get something they believe that they can justify withdrawing or at least resolving the case and not have to take it forward to arbitration. It can be withdrawn. That sometimes is the case. Sometimes unions will withdraw grievances when they're pending at arbitration. Or the grievance can be granted, of course, at one of the steps. My advice to you would be, if you're going to grant a grievance, excuse me, try to do that through a settlement agreement. There's no reason for you, in most cases, to write up granting a grievance when you can go to the union and say, okay, here's what we're willing to do as a result of this grievance to get it resolved. So why have something on the face of it where you're finding formally that the agency is withdrawing its action or whatever, when you probably can do that in a settlement agreement? Ordinarily, that works pretty well with the unions because they don't honestly care whether it's a step 2 grievance decision or whether it's a settlement, as long as they get some relief that they're seeking. Grievance mediation. Again, some of the agencies have had great success with this process. When a grievance is filed for arbitration, there is in each contract set out the ability for one of the parties to request mediation. Ordinarily, it's the union. Mediation is provided, services are provided to us by your federal government. This is your taxpayer money at work. The Federal Mediation and Conciliation Service, which has regional offices all over the country, provides grievance mediation. They've pared back a little on their flexibility with respect to this, but they're still available to mediate. It's scheduled through our office. There's no cost to the parties. You'll enjoy that, other than, of course, you traveling to wherever you're going to go for the mediation. Ordinarily, they'll schedule these in regional offices. And unlike arbitration, again, those of you who are familiar with mediation, the only outcome that's going to occur is that's agreed to by both of the parties. So if you have a case where you think it might lend itself to sitting down with the union or with the grievant, there's a variety of reasons why you might want to mediate. Sometimes it's helpful just to be able to get some of the facts and information you have before the grievance representative in a mediation session, so that they can be completely familiar with what you believe you have as a good case. And you can, sometimes the union will go back into caucus at a mediation, because ordinarily these occur in separate rooms. If you haven't been involved in a mediation, ordinarily you'll meet together first, and then the mediator shuttles back and forth between the two parties. But it can be a very effective process. Again, if you've got something that you think would lend itself to discussion and talking through agreement, and maybe you've got some flexibility in terms of what you're willing to do, maybe even an individual seeking a resignation in lieu of a termination. Again, some of the agencies have used this very effectively in avoiding arbitration, because of course in arbitration you're rolling the dice because the arbitrator makes the final decision. Here at least you have control of the outcome. So I just commend that to you as an option to consider. I've got a couple slides here relating to arbitrability. There are, in some grievances at least, there are issues that arise with respect to whether the grievance is arbitrable. And I've laid out several of these considerations here. First of all, some of the contracts have language in them that exempts certain kinds of matters from arbitration, actually from grievance. The first one there, if you have a discrimination claim, sex, race, whatever, those are not grievable through the contracts. The only exception to that is if an individual is grieving that they've been discriminated against based on union activity. But otherwise, those matters cannot go through the collective bargaining contract. In some instances, some kinds of matters, the grievability is limited to step 2 or 3. You need to be aware of those, because if the particular matter that's being grieved is limited in that fashion by the contract, then of course the union, the employee, cannot take that matter to arbitration. And there are also, as I mentioned earlier, there's some exceptions for employees who are probationary in their current position, and they don't have necessarily the same rights as permanent employees. The second issue, have the timelines, the time requirements, filing requirements in the contract been met? If they haven't, and if you've raised those early on and you haven't waived your right to assert that the grievance hasn't been filed timely, then you can take that position, and eventually we might in some cases be able to prevail on that. You might be able to at arbitration. Arbitrators are not inclined to deny grievances based on timeliness, but there are instances where they will uphold a grievance as being untimely and they won't pursue it. Is the issue already being pursued in another forum? I'm going to mention in a minute a couple of provisions in the contracts that relate to that, but the bottom line is an employee cannot pursue a matter in multiple forums. So they can file an unfair labor practice, they can file a career service grievance through PERC, they can file a grievance through the contract, but they can't do all three. They get their choice as to how they're going to proceed. An arbitrator ultimately is going to determine arbitrability. It's not in your hands, so the fact that you conclude that something isn't grievable, isn't arbitrable, doesn't shut it down. Remember, you're one of the parties, but not both. So if you decide a grievance is not timely, you have to write up a decision and say that, and if the union wants to challenge it, they can challenge it up the line and ultimately try to get it before an arbitrator. We have a provision in our labor contracts that provides for expedited hearing on these issues. So if you're asserting, we're asserting that a grievance is untimely, that can be heard in an expedited fashion before an arbitrator, and they can make a determination as to whether it's not something that can be grieved. Representation at arbitration. In most cases, if the union's representing the employee, they're going to have an attorney or they're going to have a business agent represent the employee. There are instances where the union will not represent an employee. They'll go out and get private counsel. In some instances, especially in the law enforcement area, they may be represented by a competing union, strange as that may seem. And they have a right to do that. Even though the Police Benevolent Association represents all of the law enforcement units currently, there are instances where an organization, International Union of Police Associations, IUPA, or the Florida FOP, help me there. Somebody knows what FOP, Federation of Police? Thank you, fraternal, yes, of course. A fraternal order of police, they may represent an employee even though they're within the PBA bargaining unit. The unions have a right not to represent people who are not dues-paying members in the law. So if an individual is not a dues-paying member of the union can say you're on your own, even though they're covered by the collective bargaining contract. I'm just going to touch on, just to sort of acknowledge that the career service appeal procedure here, Greg Morton, who's going to follow me, is going to talk in depth about this. But you're all aware that there is an alternative forum, alternative to the grievance arbitration machinery, which is available for a career service employee to appeal the actions that are laid out here, which again are the actions that trigger property rights, reduction in pay, demotion, suspension, et cetera. Unfair labor practices. We've had employees, we've had unions file unfair labor practices, again under the labor statute, 447501. And you can see here the various grounds that an employee would have or a union would have for asserting that there's been an unfair labor practice. Coercing employees, restraining them, the exercise of rights. So if you've got an individual who's a grievance rep, and they are asserting that you're discriminating against them or interfering with their rights to represent somebody, the union can file an unfair labor practice with regard to that. Discouraging membership in a union, so if some supervisor finds out somebody's a union member and they bring them into their office and rail about this and say, why did you make that choice and what are you doing, and and so on, and the person feels they're being treated improperly, they can file. Discriminating against an individual because they've filed charges or given testimony, somebody, for example, who's gone in and testified against your agency in a grievance proceeding. Assisting in the formation of the union, anything, or contributing financial support. So basically you need to stay hands-off with respect to the union's business in terms of their organization and operation. And the last one, refusing to discuss grievances in good faith. So if the union feels or the employee feels they're being stonewalled in terms of a grievance and you're not giving them a timely response or you're not properly processing grievances, they can file an unfair labor practice with PERC with respect to that charge. And I've just got a couple of examples here of those types of things. Not processing a grievance. Notice the second one, just tuck that away, disciplining an employee for engaging in concerted activity. There is a provision in 447 in the statute that talks about concerted activity. There's been quite a bit of activity by the National Labor Relations Board on this issue recently. Bottom line is employees have a right to get together with other employees and to pursue terms and conditions, issues relating to terms and conditions employment with them, even though they're being critical. So for example, somebody gets on social media and says, my supervisor is a, whatever, you can fill in the term. It wouldn't be anything nasty, of course, is a superb person. But if it's something a little more critical than that, they have a pretty broad range of speech rights around concerted activity. So don't jump on this stuff too quickly. If this happens to you, be sure you step back and see if PERC or the courts have weighed in on what constitutes acceptable concerted activity. Procedures I'll lay out here. I'm being given some time notice over here on my left by these are the timekeepers. They do it fingers and toes and whatever. Anyway, the unfair labor practice procedures, you can see there an individual, the union's got 6 months after the date of the event to file, so there's a significant period there that they have to consider whether they're going to file a charge. It goes to the agency or go to DMS in some cases. We have to answer, and then we would go, it's the similar process. There's a hearing officer that would hear the case, and then PERC would issue a final order that's appealable to the DCA. This is what I was describing earlier, the choice of appeal forums. Basically, a career service employee has three. They can either file with PERC with respect to a career service appeal. In some cases, they could file an unfair labor practice with PERC, or they could go through the contract grievance arbitration procedure. Of course, if it's not a matter that it implicates property rights, then they could go to go through the internal career service grievance procedure we talked about earlier. And again, this is a provision that we have in our collective bargaining agreements, which really speaks pretty much to the same thing. If they're prohibited from pursuing a grievance when it's at the same time the subject of an administrative action. So if they're over in 120, 57 pursuing a matter with DOA, if it's the same matter, they can't file a grievance on that matter, or if they've got an appeal going in court. think that's it.